We did part 2 in the copy. Part 1 was in the copy. So Scott.
Good morning, Chair Postman, Member Garrett, staff and guests. The lobbies are open and the recording has begun.
Thanks, Dustin. Good morning, everybody. We'll convene the Washington State Liquor and Cannabis Board meeting for Wednesday, February 28th, 2024. Our friend member Vollenbrock's not able to join us today. One quick small note on the agenda. We listed consideration of the rules petition under for the 314-11-050 WAC under cannabis-related rulemaking. It's not, so that'll be a separate item. Our first item of business, though, is consideration of our minutes from the January 31st board meeting. Quite a big one. Is there a motion to approve those?
This is Ali. I approve the minutes.
Great, and then I'll second that, and then those are approved. Now we'll move to cannabis-related rulemaking, and Denise Laflamme, our Policy and Rules Coordinator, will present the CR 101 for minors on cannabis licensed premises. Good morning.
Good morning. Good morning, Chair Postman and Board Member Garrett. Today, I'm requesting the board's approval to file a CR 101, a pre-proposal statement of inquiry to initiate rulemaking proceedings consistent with the APA to consider amendments to WAC 314-55-015 to allow certain persons under the age of 21 on the licensed premises of producers and processors under limited specific circumstances. The CR 101 relates to 2 rulemaking petitions that the board accepted in August 2022, both from Crystal Oliver. These petitions pertain to amending WAC 314-55-015 to allow persons under 21 on licensed premises of cannabis producers and processors in 2 different situations. The first situation pertains to reinstating a temporary cannabis license allowance that the LCB put into place during COVID that permitted minors under 16 years of age on the licensed premises of cannabis producers and processors, provided certain conditions were met. These conditions included that the child under 16 was a child or grandchild of the licensee, was not engaging in any work or active employment for the licensed business, and did not possess any products associated with the production, processing, or sales of cannabis. This allowance was put in place to support families of licensees impacted by school and daycare closures, resulting from the statewide COVID-19 response. This allowance expired on December 31st, 2022. The second situation pertains to allowing employees of contractors who are between the ages of 16 and 21 on the licensed premises of cannabis producers and processors, provided that the employee is not engaging in work directly related to the production, processing, or sales of cannabis. This would accommodate young employees as apprentices and trainees in such trades as construction, electrical, plumbing, and HVAC systems who may be on site to conduct repair or maintenance type work. The petitioner cited that the statute does not specifically prohibit these types of workers at producers and processors, and that allowing these workers could help support small independent construction companies. If approved, the CR 101 would be filed today, February 28, 2024, and an informal public comment period would be open until March 28th. Tentatively, we expect to bring the CR 102 with the proposed draft rules to the board for approval in July after conducting 2 rounds of stakeholder engagements sessions to develop proposed draft rules. If the CR 102 is approved, a public hearing will tentatively be held in August. If a supplementary 102 does not have to be filed, we expect to file the CR 103 in September, which means rules would become effective in October. As brought up during the caucus yesterday, we will look at existing statutes that allow certain workers and interns ages 18 to 21 on licensed liquor premises that may be used as templates in the rulemaking process. We anticipate working closely with enforcement to ascertain how these changes might be workable, as well as agency partners responsible for children's health and wellness, including the Department of Health and the Department of Children, Youth, and Families, among others. We would also want to seek input from labor and industries related to employees of contractors. I'm happy to answer any questions you may have. Thank you.
Great, thank you. Any questions, Member Garrett?
No questions.
No. Yeah, I don't have any either. I'm glad we're doing this. This obviously has been on the shelf for a while, so appreciate you getting it to this point, and glad that at least we'll open the inquiry and have the opportunity for people to discuss it and weigh in. So with that, then, is there a motion to approve the CR 101 for minors on non-retail cannabis licensed premises?
This is Sally. I move that we approve the CR 101.
Great, then I'll second that. Then that's approved. Thanks, Ms. Laflamme. Next item up then is the consideration of rules petitions regarding WAC 314-11050, known as the prohibited conduct WAC. And Daniel Jacobs will present that to us. Good morning.
Good morning, Chair Postman, Member Garrett. Before I shift actually to that, I did just want to, if it's okay, give a brief update about medical cannabis endorsement rulemaking.
Yes, please.
So that's one of my rulemaking projects. And actually just yesterday, we sent out via GovDelivery an invitation to 2 stakeholder engagement sessions that are going to be held on Monday, March 11th from 10 to 11:30, and Thursday, March 14th from 2 to 3:30. And we are inviting the public and stakeholders to provide comment and discuss some draft rule language that we've posted. I've sent that out via GovDelivery, that the meeting information, it's going to be held virtually, and it's posted on our website, but I just wanted to also announce it here at the board meeting while I have this public forum for a few minutes, just to sort of say, we'd like anyone and everyone to attend. If you have any question, please email the rules inbox, rules@lcb.wa.gov. And lastly, the 2 sessions are going to cover the same topic. So don't worry if you can only attend one of them, you're not going to miss something that's only talked about in the other. We're going to cover the same thing. We just want to be able to have one session in the morning, one in the afternoon, one early in the week, one later in the week.
Okay, great.
All right, great. With that, I'm going to address the petitions for rulemaking that we discussed briefly yesterday. So I'm presenting the Director Office's staff recommendation on 6 petitions that we received on January 31st, requesting repeal of WAC 314-11050, known as the Prohibited Conduct Rule. We're recommending approval of these petitions because we've already begun the rulemaking process. So as I said, on January 31st, 6 different individuals submitted almost identically worded petitions requesting 2 things. 1, the immediate halt of enforcement of WAC 314-11050, and secondly, its repeal. Via a press release made by the agency on February 1st, the board and the agency's already halted enforcement of WAC 314-11050. The petition response initially was scheduled to be presented on February 14th, when the board actually approved a CR 101 to begin rulemaking on this topic, in part to explore this very question, potentially to repeal WAC 314-11050. As you may know, engrossed substitute Senate Bill 6105 also addresses the topic of the repeal of 314-11050. And if that language passes, which I believe it may have passed the House yesterday, may make this a moot point, and it may order us to repeal the language. But even if this bill doesn't pass, we may end up repealing this language on our own via the rulemaking process. The fact that the matter that this petition, the fact that addressing this petition was tabled until after approval of the CR 101 does not change the fact that the board is already addressing this topic and intended to address this topic after receipt of the petition. Therefore, I'm recommending approval of the petition for rulemaking, consistent with the board's language and actions thus far on this topic. Thank you, and I'm happy to answer any questions.
Thanks. That makes sense to me. Any questions, Member Garrett?
Yeah, like I
Go ahead.
stated at the last board meeting, and I thought yesterday in our discussion, this wasn't going to be brought forward yet. But as I stated in the last board meeting, I'm not prepared for the acceptance of the petition on something that we are now already doing without a full board discussion. And we haven't had that full board discussion yet. So I'm not prepared to take action on this at this moment.
Well, the only thing I'd say is we have had quite a bit of full board discussion about the underlying issue of that, and it really is. It doesn't matter at this point. It's academic. We're doing the work.
Right.
I think that acting today, I wish we had done it sooner. To accept the petitions just shows the acknowledgement that we had members of the public asking us to do what, in fact, we've done. So just so everybody knows, even though this apparently won't be accepted today, it doesn't affect what the rulemaking will be or when the timeline of that is. It's just we won't be able to formally accept it, which I think was too bad, but we will deal with that. It's not necessary for us to act on it. To your Mr. Jacobs, the point about legislative action is really going to be, frankly, so much more influential in this process than anything else right now. And we've seen a couple of different versions, and I think this will be a task for our AAGs and you and the policy and rules staff really to help us on what we can do. When the Senate passed a bill on the floor a couple of weeks ago to mandate repeal of the WAC, what the sponsor of the amendment said was it was a way to hit reset. And I think we've discussed this, but there was some conversation on the Senate floor during debate about our agency's existing authority to put in place a different set of rules, which at the time led me to believe that the intent was not to take it off the books completely, but that they wanted us to get the clear message that this was a priority. And in the words of the sponsor of the amendment, it was to hit reset. The version that the House passed was amended, and it says the Liquor and Cannabis Board shall repeal the WAC in its entirety. The Liquor and Cannabis Board is preempted from adopting any similar rule as provided under Section 4 of this Act, which I think might be stating kind of the legal reality anyhow. If the legislature were to pass something, we can't just put something back in its place. But this makes it very clear that the legislature's intent, in this House version at least, is that nothing similar goes back in there. So I guess I just say that to ask you, at what point do we just wait till that bill, see what passes and what's signed? And at that point, do we just stop if that's what the law is?
Yeah. To be honest, it's been sort of hard I've sort of tried to come up with sort of plans for different scenarios, but the scenarios keep shifting a little bit. So while I had initially stated that I was tentatively planning on having stakeholder engagement sessions at the end of March and draft rule language filed in April, that was at a time when the proposed language just said repeal the rule. So first it just said repeal the rule. And then an amendment came in that said, no, don't repeal the rule. They say, but you can't make any rules on sexually oriented conduct and some other things. then they were like, no, let's go back. We're going to both repeal the rule. You're preempted from doing anything similar, and you can't make rules on sexually oriented,
Right.
which I think is the current version. So and if that's the case, I don't, frankly, we may need to change the rulemaking process, just because I don't know that it makes sense for us to go and host sessions on draft rule language if
Right.
we can't do that anymore. If we're just doing a
Right.
straight repeal. And I think I had mentioned this at the February 6th meeting, though, but because of the timeline, it may take until June to get this rule off the books anyway.
That's true.
I don't know that if the legislature passes the law and the governor signs it in, I don't know that we could do it in an expedited basis, and sort of skip the 101, which is ironic because we've already started it.
Right.
But I mean, I think, and I don't want to speak for Member Vollendroff. He had mentioned that he thinks that he had mentioned previously that he thought it was important for us to have some sort of public session to discuss it. I'm not going to make that call as to whether that makes sense. If there's nothing for us to discuss, at least if we just need to repeal the rule and we don't have authority to replace it with anything, frankly, that makes my job easier, because then I don't have to sort of debate internally about what to replace it with.
Yeah, and I agree. I'm not sure at that point we need to, well, we're going to wait and see then, I mean, the bill is changing. We don't know how fast it will both pass, be signed, take effect. We're going to keep moving on our rulemaking. At this point, again, the fact that the petitions were not accepted does not impact the timeline. I want the people who submitted those petitions to understand that we are moving forward with them. You've already started your work, as you've discussed a couple of meetings. The pace of that won't change. So if the legislature ends up not passing a bill, we're not losing any ground on this. We're going to continue forward. And the fact that we accepted the 101 gives us that ability to look at anything from full repeal to amendment of the WAC.
Right. And that was the other thing, is that oh, sorry, go ahead, Member Garrett.
Yeah, and I just wanted to say, and I spoke with one of the petitioners, Sky, last night, that in everything we're seeing and with everything that's being done, and the fact that we have opened up the CR 101 and we know what was going on with the legislators, that I don't want it to seem like I'm rejecting the petition. I'm saying I don't see where we need to go outside of our normal process to accept the petition on things that's already being done.
Yeah,
so I just want to be clear on that.
Yeah, I understand, and I think I addressed this before too. So in terms of the outside our ordinary process, we don't really have a instance to compare it to in this case, because where we diverted from our ordinary process was when we announced publicly that we were going to suspend enforcement of this rule and open rulemaking. We did that prior to having Mr. Jacobs' work on the CR 101. As we were discussing that internally on that Wednesday was when we got the rules petitions in. They were sort of simultaneous to our internal discussions. And we went ahead, of course, and made that announcement and did stop enforcement at that point. So that's where we've diverted from originally. The rule only is that we have a maximum amount of time in which we can act on a rule petition. But we're not required to wait that full amount. We almost always do, because our rules people are busy. We don't always, though. And when they're ready, they bring it forward. So acting on it, I don't think changes our standard process of accepting rules petitions. But again, it doesn't matter in this case. We're going to keep going. So we're going to table that item indefinitely. And Mr. Jacobs, we'll all just keep watching what we're doing. And I know that we'll continue to get updates from Mark Webster and you and others on what that process is going to be. So look forward to that. Sorry to make you go through this now for a third time, but that's tabled. And we're going to move to your next item, which is presenting the CR 103 for adoption on trade areas.
Not a problem. Thank you. And so good morning. This morning, I'm requesting approval of the CR 103 for the trade area rulemaking. If approved, the CR 103 will be filed immediately, and the rule changes will be effective Saturday, March 30th. As brief background, WAC 314.02.1071 defines the term trade area as it's used in RCW 66-24-630 on spirits retailers. The law requires spirits retailers to be at least 10,000 square feet, subject to a few exceptions. One of those exceptions is if there are no other spirits retailers in the trade area of the proposed new store. Another exception is if this premises used to be a state-owned liquor store. This means that you can open a spirits retailer that's smaller than 10,000 square feet if, among other things, there aren't any other stores in the trade area. But the term trade area isn't defined in statute, so we get to define it in rule. Currently, trade area is defined as 20 miles, again, unless we are talking about locations on some of the islands or former state liquor stores. When the rule was initially created after liquor privatization in 2013, there was a proposal to include stores on tribal land and owned by tribes in the list of exceptions to the 20-mile requirement. This would have allowed stores on tribal land or owned by tribes to open regardless of the square footage. This proposal did not make its way into the final rule language, and some tribes were unable to open spirits retailers as a result. We filed the CR 101 in May and circulated draft rule language initially in July and then again in October before we had tribal engagement sessions and stakeholder feedback session in November. Following the stakeholder feedback session in November, we got some industry feedback that we didn't end up incorporating into the draft rules. Those draft rules were filed on January 3rd, and since then we've received no written comment on the draft rules. However, there was testimony provided at the February 14th public hearing in opposition to the rule changes, and I will address that testimony momentarily. The proposed rule language does three main things. One, it removes an outdated reference to how LCB measures 20 miles. Secondly, it cleans up the language about the retailers that are located on some of the islands. And third, it adds in language exempting retailers in Indian country owned by tribes or tribal enterprises from the 20-mile distance requirement, as well as we define the term as Indian country and what counts as a tribe, both making reference to federal regulations on the topic. Now, during the public hearing, individuals representing former state liquor stores testified in opposition, stating that they believed that this rule change would dilute the value of the trade area, which they understood as being purchased with the rights to these former state liquor stores. They testified that there was a sense that the LCB was changing the terms of the deal a decade after these rules were initially written. And there was also a concern that this would allow the dramatic proliferation of liquor stores in Washington state. As I mentioned in the concise explanatory statement, just reviewing the timeline here, Initiative 1183 was passed in November 2011. The state liquor stores were auctioned off in the first round in May 2012, and then those stores that didn't get auctioned off then were auctioned off a month later. In late May 2012, so after the first round of auctions, we filed the 101 saying, hey, we're going to define what trade area is. But that was just the first step. The final rule language giving a proposed definition for trade area in stating that it would be 20 miles, and the debate about whether or not to include or exempt tribal stores in Indian country, that didn't happen until March 2013, which is almost a year after the auctions happened and almost 9 months after the purchase of former state liquor stores had occurred. Next, just to clarify, this rule change would only allow for new liquor stores that otherwise could not have opened because these stores are smaller than 10,000 square feet. So as I mentioned in caucus yesterday, this rule change isn't going to allow a Bevmo or a Total Wine & More to open in Indian country because those could have already opened. If they're bigger than 10,000 square feet, this rule doesn't change anything. Regarding sort of the notion that we're changing the terms of the deal, LCB retains rulemaking authority. We had rulemaking authority then to define the term trade area, and we still have it. we have the authority to change the rules, and we do so all the time. We didn't make any assurances at the time that the rule would stay permanent, because that's not something that we do. Any rule changes, additionally, if a rule change would dramatically affect the cost or impact to small businesses, there's a regulatory mechanism in statute to sort of force us to go through that analysis, which is a small business economic impact statement. If these rule changes would have dramatically affected these small liquor stores, we would have been required to do this analysis at the 102 stage. And based on the economic analysis we did at the 102 stage, that wasn't needed. Lastly, as I've previously mentioned a few times, all indications from the tribes that we've received are that only a handful of tribes plan on taking advantage of these rule changes, namely those stores that previously weren't able to open a liquor store on their sovereign land. While theoretically it's possible that a tribe that already has a liquor store could now open another one, frankly, if it already had a liquor store, it could already open another one bigger than 10,000 square feet. Maybe this will now allow it to open one that's smaller than 10,000 square feet. But again, if it's smaller than 10,000 square feet, I'm not sure the sort of how big a competitive impact it's going to have. But regardless, our intention all along has been to allow tribes to conduct their business on their sovereign land. And that's what we intend to do through this rulemaking. As such, I'm requesting approval of the CR 103 on the trade area rulemaking, and I'm happy to answer any questions.
Any questions for Mr. Jacobs? No. Okay.
No question.
Me neither. I'm glad we're doing this. I think it's a good step. And so would entertain a motion for the board to adopt the CR 103 for trade areas.
I move we adopt the CR 103 for trade areas.
Great. And I'll second that. Then that is adopted. Thanks, Mr. Jacobs.
Thank you.
Okay, we are to the point of the meeting for our public comment. As I think most people know, but just to be clear, everyone has up to 4 minutes to speak. We ask you to limit your comments to LCB business as much as possible, and of course, refrain from any kind of personal attacks. Please be respectful to the speakers and everyone who's present, both online and in the room. A reminder for those that are in the room there, the microphones in the room are very sensitive. They pick up wrestling paper, side conversations, typing on your phone, all sorts of things. So please, let's just give people our attention and take any kind of other activity out into the lobby, please. Just a reminder, we record it all. Of course, it'll be available online, either through the Teams or the TVW listing. When you get your name called, you'll give you a second to get settled online here. We'll find you. And when you have 30 seconds left, Dustin will give you a quick heads up to let you know it's time to wrap up at 4 minutes. And with that, we will start with those. I've got 2 signed up virtually. The first is Sammy Sod.
Good morning, Chair. Sammy Sod registered to speak, but is not online with us today.
Okay. Then David Busby.
Good morning. Can y'all hear me all right?
I can. Good morning.
Awesome. Thank you. I'm here to chat about CCRS. You guys had announced last couple of weeks, came out some announcements. CCRS was going to be offline for some updates. And I think that worked out swimmingly. You know, I'm usually in here being rather critical of the compliance system. You know, I deal with it a lot, so I see a lot of these edge cases. I've noticed the response times have improved a little bit, so maybe that was something that happened in there. I had some other annoyances that I had filed bugs on about CCRS. Some of those seem to be improved in the UI, you know, when I sign in and do stuff manually, which is also excellent. You know, I think it's it's a good show that the state has decided to like own the technology stack on there. I mean, you know, I have some feelings about that tech stack, but the fact that you're owning it already and making those improvements is a good show. And, you know, it also is demonstrating that a state agency can take ownership of that stuff and doesn't need, you know, out of state vendors with very expensive proprietary technologies that then cause some complexities for the agency. You know, you can move at the speed you want to move at. And I think, you know, I'm in here critical really a lot. So it's important to also say, this is a good show. This is well done. Yes, and that's it. Thank you.
Great. I appreciate that. Good day. Now we'll move to people who are signed up in the room, and want to call your name. You can come up to the podium. First person signed up is Sky Thuriot. Let me know if I've pronounced your name incorrectly.
Thank you, Chair Postman. It's Terrio, but
Thuriot, I'll remember. Thank you. Hi, Sky.
hi, members of the board, staff, and the public. My name is Sky Terrio. With the recent passing of the Engrossed Substitute Senate Bill 6105 in the House, it's obvious that the Liquor and Cannabis Board has an undeniable duty to repeal the WAC 314-11050. I stand today in gratitude for the board's swift action on this process. The positive enforcement has been felt in our community up in Seattle. And with the CR 101 having been filed at the last board meeting, your actions are likely to take effect before the January 2025 that's currently listed on the legislation. So even if that bill does get repassed in the Senate, we will still be half a year ahead of schedule, which is going to have a really important impact both for the LGBTQ plus bar community as well as the Strippers Are Workers organization, who've been fighting much longer on this issue. As I've said before, these rules have demonstrably been unfairly enforced and caused harm in the lives of many LGBTQ plus citizens across our state. And as I see it, Washington State must be a beacon of hope in a nation wrought with bigotry and homophobia. While consistency does have its place in government affairs, when we find rules that have disproportionate impacts such as these, it is important and infinitely valuable to break from those consistency patterns to show the public that we're no longer interested in maintaining laws that don't serve the public as a whole. And as I've shared in previous public comments, being able to be partially or fully nude in licensed establishments has in very plain words saved my own life. Many can ignore the benefits of a positive impact on mental health because it's not nearly as visible as something like weight loss or physical health changes. And this silent relief is one that many in our community are seeking. Having safe spaces to receive this mental health relief is paramount to undoing decades of damage caused by navigating the world around us safely. As I mentioned on the call with Member Garrett yesterday, I grew up in a place where I was physically assaulted before I even came out, and then increasingly physically assaulted as I did come out. So when I look to Washington to be that safe beacon, only to then be harassed by an enforcement team of this agency, kind of sent a shockwave of trauma back through my life. But again, I express my gratitude for your prompt attention to this, and I look forward to seeing this process through to the end. Thank you.
Great. Thank you for your comments. I see Mr. Saad joined us, but we'll come back to Mr. Saad online after we finish those that are in the room who are up next. So stand by there. So the next person signed up is Chad Sweeney.
Hello, Chair Postman, Member Garrett, and board members and staff. My name is Chad Sweeney, and I'm here to speak about the board's rulemaking process for WAC 314-11050. First, I also want to thank the board and staff for listening to our communities and listening to our concerns. We have felt heard and recognized, and that means a lot. As we talked about, the legislature's spoken. Both houses have directed the LCB to either repeal or significantly revise this rule. And I'm here to advocate for immediate action from the board to completely repeal the rule. I believe the LCB should act quickly and decisively to remove this harmful, outdated, and unnecessary language from the Washington Administrative Code. A full, unequivocal repeal of this rule is the right thing to do to promote safety, inclusion, and community in licensed establishments. And adding or retaining any language that describes behavior that's acceptable in licensed establishments is duplicative, unnecessary, and confusing. Washington statutes already make it illegal for individuals to display their body parts in a way that could cause affront or alarm to another. It's already illegal in the state of Washington to non-consensually have sexual contact with another person. So retaining any rules of conduct that distinguish between what's acceptable in a liquor establishment and what's acceptable in any other public place will continue to make queer spaces vulnerable to the exact kind of problematic and intrusive enforcement that brought us here in the first place. LCB has the capacity and expertise to make rule changes using the existing statutory mechanism that you've already started. So I urge you to use this mechanism to fully repeal this harmful rule. Thank you.
Great. Thank you for your comments. Next person signed up is Christopher King.
Great day to everyone here. Thought I'd make Black history today, being the first Black man to drive from Mount Vernon to come down here to a board meeting, because the Black history that was postulated and put online by King 5 at the first of the month turned out to be a false narrative, okay? Because it said that Dennis Turner was this new social equity candidate who got a new store in Arlington, Washington. Well, as y'all know, I lived in Arlington for 3 years, okay? I know the community very well. And he's not new. I have all of the licenses before. He was with Lucid. He was with Turner, Vuskovic, and Aguiar. He had a Euphoria. He had another Cloud9 entity before. He's been around the block. And that's one thing, because the social equity program was never designed to help people who had existing 502 licenses, was it? Why would that be the point? That makes no sense, all right? It was to help people like Kevin Shelton, who's filming me right now, get what was taken from them by people like Jenny Durkin, when Jenny Durkin was busy violating the heck out of the Ogden memo, sending go-to-hell letters to all the Black pioneers, threatening them that they needed to get out within 30 days. Yes, she did. And her excuse to Ann Cottinelli on the video project, I'm not even going to get into her excuse yet. I'll let Ann do that, but that's ridiculous. So anyway, we had a false narrative with that. But what I'm finding to be much larger of an issue is that the LCB has an ongoing history of buddying up to people with nefarious backgrounds. Where should I start? How about the whole way that Ian Eisenberg did what he did on the South End down there? That was disgusting. But more than that, there's a family called the Widmer family we've talked about before. The Widmer family, where your own lawyers, Mr. Postman, wrote, and I quote, that he's involved in some transactions, various financial transactions, would turn your hair white, okay? Millions of dollars of fraud findings against his companies, and he gets licenses with Khalifa, okay? What's up with that? He lied to the U.S. trustee. He hid the Porsche. He hid the Rolex. He hid everything. He lied to you, Mr. Postman, and you still let them get licenses. It's the same with Dennis Turner. He was involved in that case with a case you have to know about that I told you about before. Turner, Quinn, and Pang, and it was what's-her-face that sued them with alkaloid cannabis. She now owns that. Greider is her name. They were double dealing behind her back. She found the property, took out a $115,000 loan to get it ready, okay? Then they burned rubber on her, and I had the court order. It's right here. Assessments, $178,000, $350,000, $437,000 for her. Again, and he was involved in all of this. So if that's not acceptable, and it's not acceptable to me or anybody in this room, is it? Why are people like him getting licenses under the false premise that he's a new social equity candidate? Well, people like Kevin Shelton sit there in dismay. This makes no sense. But that's what the LCB does. and you say you're ushering in this new era of transparency, you won't even give me the CV of your director, Bill Lucala, okay? Let's face it, it is not unreasonable for a citizen to ask for the CV of the head of a public agency. I am not the problem, and I refuse to let anybody in this room ever insinuate that I am the problem.
Christopher, you have 30 seconds.
Thank you. I have never been the problem. The LCB has always been the problem. And as I discussed with Sky a few minutes ago, we're going to get up and do some things together because I have no problem with GLBTQ. My partner identifies with that community. I've helped that community before. I'm good with them. We don't have a problem, but we all have a problem with you. And that's not my fault. It's not his fault. It's never going to be our fault. You have left the Black community in shambles for 10 years now, and I'm tired of it. I've got handouts for everybody.
That's your time.
I'd like a stamped copy of this back, please. I've got handouts for everyone so they can see the truth that major press won't talk about.
Okay. The next person signed up is Kevin
There you are.
Shelton.
Here.
Good, man.
Okay.
I got nothing to say.
Kevin's good. Kevin's good. You can move it along. I can get a stamped copy of this back.
Chair Postman, Kevin Shelton is yielding his time.
Okay. Then Peter Manning is the next person who signed up.
Good morning, Chair Postman, Board Member Ollie Garrett. I am Peter Manning, President of Black Excellence Cannabis. I'd like to start off by saying that a little bit of recognition needs to be handed out. 2020 Black Excellence Cannabis, a pioneer, the 42 licenses that came out last year. Last year, Black Excellence Cannabis helped create 52 retail stores, 100 processors, and 10 producers, with the Vice President Mike Asai at my side. Black Excellence Cannabis has really been fighting this fight for the last 10 years. And for those that have questions, that's 204 opportunities that we have given or brought to the Black and Brown community of Washington. The sad part of that is that these opportunities should have been given to the Black and Brown community from the onset of social equity or cannabis period in Washington. There should be no need for a social equity program here, being that we were all made privy to the problems that we were faced with in 2015, as well as 2016, as well as 2017. My point being, we are now at the crust of where the 42 licenses were supposed to go live. We at Black Excellence Cannabis did look into the Arlington situation. We have to agree that that is not what we consider social equity. That was not the target to give it to someone that was currently in the retail sector and then to be glorified on the media as if job complete. The job is not complete until we reinstate those people that were stripped out of King County, Pierce County, and Snohomish County that legitimately had places of business such as dispensaries that were in those cities that were run out through cronyism, nepotism, whatever you want to call it, and was replaced with white people that had no idea what the cannabis sector was like. The Black and Brown community was hurt there. I'd like to move on to my third point, or my fourth. The social equity, the LCB gave the social equity applicants that did get the letter of approval, they gave them a direct link to a women's minority group that was supposed to help with funding for those applicants. Everybody with a hope and a prayer reached out to those people. Black Excellence Cannabis looked into it. It turned out that that agency or that entity was only a referral center. The LCB was marketing that as if that was where the money was going to come from. So our question at the Black Excellence Cannabis, Mr. Postman, Chair's Postman, where is the money for these stores at, man? We got to have dialogue there. Ollie Garrett, we need dialogue on where this money and when this money's coming. We have no idea where this is at. It is most definitely hindering this program. We would like some transparency. Thank you very much.
We'll go back online and Mr. Saad, if you're there, you can go ahead. Dustin will connect you.
Hello, everyone. How you doing, Mr. David, and everyone in the room, and Ms. Elliot, and Erica, Michaela, and welcome to Washington. I just wanted to say something. In my we disagree in the past, and we can disagree about something. I just would love from you guys to see in the future those black pioneers, the one they started the medical, to be acknowledged in those 40 license. The rubric, I'm one of the winners. I own the first medical cannabis shop ever in Washington. I'm the first one. I've been forced out long time ago. I get my opportunity this time. I'm overqualified, not just qualified. And I really, like I said, some people got a lot of people they started they didn't get. So there is no a fully equity. There is no justice. But I'm not gonna blame the whole board on this. I'm blaming those fake leaders in the community. They reflecting the wrong way to the board to make them accept the rubric and those point program, and some people being arrested and some people being having cannabis shop to have points to get their shops. If you take from somebody, you should give them first. So make it half and half. I wish the board to work with the people to build a trust with the community, so it will never be a frustration. I'm one of the winner, but I still feel like I'm a slave to the LCB in a certain way, because the fake leaders, those our black leader, and they don't represent us in a right way. They reflect to the board. Hey, you have to put a certain restriction. Nobody can change percentage until after 1 year to those social equity applicant new store owners. This is not right. Second thing is the work on commerce, they don't want to give people money to secure their store. If I can have my store, I have the fund. Other people don't. I'm looking for other people too. So if I love from my brother, God give me and give them. So I'm not blaming all for the board. I'm blaming those fake self-appointed leaders. So I wish the board to work with the people, and I trust, Mr. David Boltzmann when he said, "Hey, this is the point. It's gonna be this." I look at it. I say, "Hey, if it's this, I'm a winner." I told him that a long time ago, and I look at it, and they have a different agency, and that agency they don't know us, and they have many agencies, and I'm one of the winners. So I trusted what is being put. So I'm not blaming the board. So the social equity going forward is kind of not the best. Is going forward, but those. I wish the board don't listen to those people. They say, "Oh, we are this, we are that." We all asking for those pioneers to be acknowledged. Trust me, it will be some success. It will be people will be happy. Second thing is very important. CR 103 about that. For us as a social equity applicant, we should not be include something like that. We're being forced out. So I want to open a shop in Renton. Now, all the license in Renton owned by Evergreen Market, and he bought the last shop from Emil Hayes, and now we cannot even have something like that. I was in a city council meeting with Mr.
Sammy,
Eddie.
you have 30 seconds.
He said he will call me. He never called me. Yeah, Mr. Eddie never called me. As a people, Caucasian, they will try to help me. Our own black people, they don't want to help me. Trust me. It's not about color. Trust me. That's why I believe on fairness. So we don't blame Mr. Eligate, Miss Eligate. We don't blame Mr. David. We blame those community leader. But I wish Mr. Those you guys, the board, just understand those people, acknowledge those people. Trust me, it will be some success, and it will be people going. But I really thank you, all of you guys.
Sammy, that's your time.
And I
Great.
really just one thing. I thanks all of those people from the licensing department. They reach out to everyone, to all the applicants.
Very good. Thank you, Mr. Saad. Okay, that brings us to the end of the agenda for today's meeting. So we're going to adjourn the board meeting for Wednesday, February 28th, 2024. We'll be back next Tuesday, most likely, for our next scheduled board caucus. We're adjourned.
Okay.